Yes, Lincoln.
Steve then Machete.
Is for the prosecution. Yes. Making the box.
Yes.
The matter my name is good. I'm appearing together with my senior.
Is Omega and the lead counsel appearing together with Mr. Amanda, who is online, and Ms. Wewa on behalf of the Kenya National Human Rights Commission, watching him on behalf of the family.
You all understand English, I believe. Yes. Thank you. This is the ruling. Two applications were made before me this morning. Both were made by Ms. Okok, learned prosecutor. The first one was to have Nakuru CM miscellaneous application number E143 of 2025, the DCI vs. Stephen Machete Musodo, consolidated with the instant matter as they relate to the same course of action, only that the suspects were arrested in different times. I allowed the application, albeit reluctantly. As we are still dealing with pre-charge application and not the substantive application at trial, let me not articulate it further, having allowed it. The second application, and that which forms the substance of this ruling, is the applicant's application seeking extension of time within which to detain the suspects to allow the finalization of the investigation. In brief, Ms. Okot outlined the following grounds in support of our application, together with what is deposed to in the further affidavit sworn by number 241343, Inspector of Police Patrick Washira. A. Investigations are yet to conclude. B. More suspects have been arrested, hence need to encompass them in the investigations. C. Investigations are yet to record crucial witness statements. D. There are other witnesses who are still being sought out for purpose of recording their statement, some of whom escaped for fear of their lives. E. DNA profiling is ongoing, and final report is yet to be received from the government chemist. F. Analysis of 7 mobile phones recovered from the suspect is still ongoing. G. CCTV footages have been received by the investigating officer and they are still under examination. H, that there are still about 5 other suspects who are yet to be arrested. The learned prosecutor concluded as submissions that it is only necessary that the application is allowed and the suspect be detained for a further 21 days. Ms. Wamaida, in agreeing with the prosecution, asked that the complexity of the matter is that which calls for extension of investigation time. She submitted that the family of the victim she represents are looking for justice, hence it's only fair that the application is granted. Mr. Guto, also appearing for the family of the victim, submitted that the matter has elicited public attention as the matter is a public interest one. He submitted that compelling reasons have been advanced by the prosecution to warrant denial of bond to the suspect at this stage. He added that the security of the suspect cannot be guaranteed following the agitation by members of the public. Ms. Wewa, counsel appearing for Kenya National Human Rights Commission, presented a rather interesting analogy that the first to fifth respondents having been previously detained, the sixth respondent should too be subjected to the same treatment. None of the respondents had any objection to that application. I deem it proper to begin that the law protects the victim in equal measure as the persons arrested. The rights of arrested persons are espoused in Article 49 of the Constitution. Of interest is Article 49(1)(h), which provides, quote, an arrested person has the right to be released on bond or bail on reasonable condition pending a charge or trial unless there are compelling reasons not to be released, end of quote. The application is in reference to rights pending charge. May I point out that the first to fifth respondents were before me on 3rd of February 2025, where I granted the investigation 21 days leave to detain them. The sixth respondent appeared before my colleague on the 14th of February 2025, where investigations were granted 10 days leave to detain the suspect to allow the conclusion of the investigation. The applicant, that is the Director of Criminal Investigation, is again before me seeking this court's discretion to extend the period of detention of the respondents for a further 21 days. Inasmuch as the applicants had no objection to the application, this court is bound to assess the merit of the application and determine its propriety. I say this especially bearing in mind that the suspects herein do not have legal representation. This subject of pre-charge detention has been discussed extensively by the Superior Court. A case at hand is Michael Rotich vs. Republic, 2018 EKLR, where Kimaru J., now Judge of Appeal, said the following, quote, the issue that has been brought to the fore in this application is the recent emerging trend where an individual is arrested by police, brought to court, and before being charged, the prosecution requests for such individual to be placed under police custody for some time to enable the police complete their investigation before a formal charge is prepared against such individual. The right to liberty and freedom is a fundamental right that is inherent to every human being. Article 29 of the Constitution recognizes this as a fundamental right to freedom, and it provides as follows that every person has the right to freedom and security of the persons, which right include the right to be a deprived, the right not to be a deprived of freedom arbitrarily without a just cause, b rights not to be detained without trial, except during a state of emergency in which detention is subject to Article 58. End of quote. The Constitution has put in place safeguards to protect right to liberty, which is a sacrosanct and a fundamental freedom which other rights are enjoyed. A similar view was observed by Murithi J. in Betty Chemutai Mayor First Republic 2018 Ikela, where the judge rightly emphasized on the prompt production of a person charged before court so as to be charged or inform the reason for his detention. Looking at the above, it is a consonant conclusion that in as much as the state has the right to investigate offenses and to use all necessary mechanisms at its disposal, the need to protect rights of suspects or persons of interest, and in particular the right to liberty and freedom, must always be safeguarded and only limited as provided for under Article 24 of the Constitution, as less liberty does not necessarily mean a proper and successful investigation. My view is that pre-charge holding or detention may only be allowed where there are compelling reasons based on compelling evidence, while balancing the right to liberty of individuals against the need to secure evidence. That is the criteria that must be satisfied, lest we convert Article 49(1)(h) to enforcement of what I call law of the lawless. May I be precise that in the instant determination, what constitutes compelling reason is only limited to the extent of the conclusion of the investigation and not the substantive trial. In this regard, and with a lot of respect to the applicant, the reasons espoused are not properly articulated. I though cannot water down the issue of the suspect's security at this stage. This, in my view, may have informed the suspect non-contestation of the application, though nothing has been presented before me either in support or against this ground. In the end, and upon placing the application at a stage